basically. These are different than business to consumer contracts, and we will explain in a bit what the difference is. Today's lecture is going to be about the most common pitfalls and also to have a better understanding of what a business to business contract is, the importance, etc. And then we can also discuss a few examples from the daily life or perhaps mistakes or different types of experiences. So today's lecture is to inform everyone, and it doesn't constitute legal advice for a specific scenario, but I think that's quite clear. It's meant for informational purposes only. And yeah, that's why it's also suitable for everyone from a different background. So today we're going to first discuss what are business-to-business contracts. So what is a business-to-business agreement? Well, it's basically a legally binding agreement. The name already says it, between two companies. So a business-to-business contract, they are supposed to outline the terms and conditions of the business relationship. Okay, because it governs the relationship between two different entities. And it should detail what each party is expected to deliver and receive. So for example, you could maybe think about selling a product, or you could sell a specific type of service. A product, it could be anything like, for example, maybe an electronic course you might want to follow, or perhaps you're thinking about selling a book, or perhaps you might sell a house, for example. If you want to deliver services, services are usually more based upon an hourly service of, for example, consultancy services, or maybe if you sell software, you are expected to deliver a type of quality of the service as well. So the purpose of a business-to-business contract is to mainly set a clear framework for business transactions. And a business-to-business contract can help to prevent any misunderstandings by a few different things, because there are many items you can actually include in any type of contract, but it should be very clear through the agreement what are the responsibilities of both parties involved. So which party will deliver what under the agreement, which party will create, for example, the product, what could be the estimated timeline, what type of payment method or payment amount has been agreed upon, what are the terms for terminating the agreement. For example, maybe you're not satisfied anymore, or perhaps you are not able to deliver the services anymore, or perhaps the relationship between the two parties is harmed and you don't intend to work together anymore. Or perhaps you're going to sign a 5-year contract because it's a very important agreement because of all the investments you have done. All these type of critical aspects must be included in the business agreement because they govern the relationship between your company and another company. So it's really important to think about, if you are thinking about a business-to-business contract, then what are the biggest risks you would like to minimize? What is going to be agreed on by the parties? Why are you even thinking about a contract? What should it be covering for both sides? What can you expect to deliver and receive? And it's also really important to think about termination. So a business-to-business contract mainly serves to avoid misunderstanding, because if we only agree upon terms and conditions verbally, it's going to be more difficult for us to prove. Like we discussed in another lecture, if it's only verbally concluded, it doesn't mean it's not valid legally. It can still be valid from a legal perspective, but it might be more hard to prove. And it has to meet a few type of aspects in order to become a agreed upon contract, which can be in writing or verbal. So we have now discussed the very basic understanding of what are business-to-business contracts. The purpose can be different. It depends on the type of business-to-business contract, and I'm also eager if you can maybe think about any type of agreement in a bit. The importance can be of a major role, which we will discuss later. We will also discuss today what are the key elements of a contract, the common pitfalls. So hopefully you can learn from them and avoid these in your own personal life as well, and the most essential clauses that should be covered in a business-to-business contract, in general speaking. So why is it important to have a business-to-business contract? Can anyone maybe share your thoughts here? Why would it be really important to have a contract into place?
If you've missed that invitation from attorney Lynette Davidson, ladies and gentlemen, it is about your thinking, your thought, what you believe is important to have a business-to-business contract. If you want to share your point of view, you may do that at this time, or you may also go ahead and type your impression, your belief, your philosophy in the chat box. Elvis Ondego, you want to say something?
Thank you, Dr. Valsin, for that time. Attorney Lynette, I think in terms of different jurisdiction, I think it is important to have agreements so that business don't bring conflicts. Most of the time, you'll find conflicts will arise when it comes to the share capital most of the time. So it's important to sign the agreement prior to any engagement in terms of business-to-business agreement. But I don't know the different jurisdictions, how they handle it. Maybe from your perspective, the United States jurisdiction, I don't know how it goes.
Yes,
right.
That's a good question you're asking, and thank you for asking this question because it's very particular. In many jurisdictions, there are laws to regulate business-to-business agreements and the relationship. And for example, in the Netherlands, we have the law which regulates the type of contract, for example, and we have a lot of freedom to arrange what can be concluded in any agreement. It is different per jurisdiction how it should be concluded, but in many jurisdictions in the European Union, for example, the European Union has its own regulations which all member states of the European Union must follow. So in the States, for example, it can be different per state law. So it can vary per jurisdiction what should be maybe done in case of any dispute, or maybe the case law can be different per jurisdiction as well. So the things we will discuss today are the most basics of a business-to-business contract. And you can find these in many type of agreements all over the world. So mainly in Dutch contracts, but also in contracts in the States or UK. I am a lawyer. I'm not an attorney at law, but I'm a lawyer, and I mainly focus on contract law. And in any type of agreement between two business entities, even in the States, you should define the role and responsibility of the parties involved, the termination clauses, the payment terms, the liability. These type of clauses are the most essential in any type of contract, and you can see and find them in most of the jurisdictions all over the world because they govern the relationship between two entities.
Thank you very much. Columbus and Gelese, you have something to say about that? Columbus?
Thank you. I hope I'm heard.
Yes, sir.
Yeah. I think why we have a contract between business and business to make sure we know our boundaries, because you don't want to cross boundaries when you are doing business with each other. You need to know the boundaries, and once you do the contract will guide you where to end and where to start from. That's
All
one.
right,
The
thank
other
you very much. The sound is not very clear, Columbus. I apologize. And let's go to Domitor and Sakala. What do you think? Demeter, Sakala?
Yes, hello. Can you hear me?
Mm-hmm.
Okay. So from my perspective of view, business-to-business contract is the most important to due to the compliance and governance, ensure confidentiality and some operational efficiency. I think this is one of the key points in the business-to-business contract, where we can minimize misunderstanding, miscommunication, and also improve collaboration.
Thank you very much. We have some ideas also shared in the chat box. Sabina Colong says it's vital to have contract to protect all parties. Francis points out the agreement of B2B is to protect the two businesses with the transaction. Dean Gandu says contacts give security in business. Well, I suppose believes it is important to have contract in order to be able to resolve conflicts during the execution of the contract. And finally, the last one on the chat section, Chuma Tabiso indicates that B2B, business-to-business contracts are necessary to define the service or offering what the responsibility and obligations of each party are, the terms and conditions, as well as the termination terms. I read verbatim what those participants wrote on the chat box. I'm sorry for that, but that's part of what we're doing, as allowed by Professor, attorney, lawyer Lynette Davidson. You may continue, Lynette. I'm sorry for that interruption.
Thank you all for sharing your thoughts, and your answers are quite correct and very important. And I think it's really, I appreciate that you think along with today's lecture, because it's important to think about why is it so important to us or to you. So one of you just mentioned it's important, and it's true, to clarify the rules and responsibilities. And what is the difference between a business-to-business contract instead of business-to-consumer? If it's business-to-consumer, it's a business selling to a natural person. If I'm selling to an entity, the liability can be very different because it's a company I'm working with instead of an individual. So it's really important to provide through a contract a detailed description of the services or perhaps the product you are going to sell. But it can also offer you legal protection, which may be even more important. So because you have put things down in writing, for example, the product you are going to sell to company number X, and you can expect this maybe on the 1st of December, if the company is going to fail to provide you the product, you can now hold the company liable because there's a contract in writing. And you could, for example, sue the company because there is a failure to perform under the agreement. It's a breach of the agreement. So it's really important for different reasons. So the first one we just discussed, because a contract can give you more precision. It's more clear what is going to be performed under the agreement. So both parties have a mutual understanding. If you only agree upon specific items verbally, you might have a misunderstanding down the road because terms can be defined or interpreted in different ways. So for example, if I tell you I will provide this to you as soon as possible, what is as soon as possible? Is that within 1 day, within 24 hours, within 8 hours, within the business day? Promptly, what is promptly? It's a very common legal term, but what do these terms mean? So if I will tell you, I will deliver you the product for, let's say, 3,000 euros. Okay, but what will be the payment terms? Am I going to request 50% of the payments prior to engaging your services, or can I maybe pay in 3 different installments? What will be the terms? And what will be the liabilities, responsibilities of the parties? What are going to be the deliverables? When is the product deemed approved? Is there any specific procedure we must follow? For example, if I will create a digital product for you, can we maybe review the product for the next 5 days and then tell you if we approve the product or not? How does this process work? Will this be done in writing, or maybe we agree upon a timeline of 2 weeks for review of the product, for example? So it's really important to have a clear mutual understanding. So in any type of misunderstanding or dispute down the road, there's a clear process outlined that both parties can follow. It can also help to mitigate risk, because if you outline the potential risks and liabilities, you can prevent unforeseen disputes. So for example, if we will have a dispute about maybe we understand a term not the same way, and this term is not outlined in the agreement, because usually in the agreement, you can start with a section with terms of the agreement and the definition which is given to the specific term. So for example, if I define intellectual property, what can we understand by intellectual property? Or perhaps maybe a client, when is a client a client? Is that a client that might be interested in the services? Is it a client who has an active engagement? Or is it a client who was engaged now and during the past 6 months? Like, what will be the definition you can give to a specific term? If we have a dispute later on, then we can, for example, agree upon mediation. But when we try to resolve disputes amicably, meaning directly between the parties, so between doctor and me, for example, if we have a misunderstanding, we could also perhaps appoint a third party, a neutral third party, who will do the discussions on behalf of us. So we can still try to come to a resolution on a direct way. And then, for example, we can proceed with mediation or arbitration or perhaps litigation. So it's really important to try to clarify as much as you can the most important elements that govern your relationship between your entity and the other entity through an agreement. Because if you create a well-structured contract, you will also allow yourself to have more confidence and more trust in your relationship, because you can avoid disputes and you can perhaps improve a long-term partnership, because it's very clear what you can expect under the terms of the agreement. This is why it's important to have a business-to-business agreement put into place. So if we continue with the most key elements of a contract, we can think about a few different things that a contract must meet in order to be binding. So the first one is there must be an offer and acceptance. What does an offer mean? An offer means there is a clear proposal made by one party to another, intending to create a legal obligation upon acceptance. Why? Because if I will create any offer, but I have no intention to create a legal obligation, there is no offer and acceptance. So, for example, you can see in many offers, sometimes even in an email, that the offer itself is not binding. Okay, the offer needs to be accepted, and the acceptance must be confirmed in writing. Only then it becomes legally binding. So, mutual intent, what does that mean? It means that both parties must intend to enter into a legally binding agreement. For example, if we're going to have a lot of drinks tonight and we're going to discuss some items, and I will tell you I will sell you my car, or my company will sell the car to you. Maybe we're just joking. We do not have the intention to enter into a legally binding agreement. So it doesn't create legal rights you can pursue. This is really important. There must be a mutual intent to enter into an agreement. And this is often demonstrated through the terms and conditions of the contract, because usually it stipulates in the agreement that both parties are willing to lay down and stipulate their rights and the terms and conditions through this agreement. That's usually included in the agreement. A consideration, what does that mean? Well, it means that something of value is exchanged between the parties involved. It can be money, services, goods, or a promise to act or refrain from acting. These can be many different things. It depends on what you want to deliver or perform through the agreement. And capacity, that means that you must have the legal ability to enter into a contract. So you must be sound of mind, not under duress or undue influence. So for example, if you are under influence, or maybe you're 11 years old, then you cannot enter into a legally binding agreement. So I hope these items are clear. And then also the legality of purpose. Well, it must be legal and not against public policy, but these things make sense. A contract must involve legal activities. If I'm going to sell weapons to you, it's not enforceable because it's against public policy. And that's quite straightforward. So now we come to the next topic, and we have to identify the counterparty of the agreement. So if you are going to sign an agreement, we must ensure that the correct party is legally bound by the contract. That sounds very simple, but it might be more complex because, for example, if I will sell a contract with company B, but company B is a subsidiary company and I want to have a relationship with the parent company and the subsidiary company, then we have to ensure that the person who is signing the agreement and putting a signature and the name of the representative, is this person authorized and able to enter into the agreement. So that's really important to think about. Who is the counterparty? Who are you going to sign the agreement with? And is this the party who should be signing the agreement? Perhaps this party seems authorized, but it's not authorized yet. Perhaps maybe it's an LLC that's not incorporated yet. If it's not incorporated yet, it cannot sign an agreement. Then the person who intends to create the LLC can sign the agreement, but you cannot keep an LLC bound if there is not a entity incorporated yet. So you have to check that the signatory, the person who will sign the agreement, has the legal authority to bind the entity. If this is not the case, the agreement might not be enforceable. And the person who signed the agreement might be constituting a wrongful act, such as committing fraud, for example. So if you can always try to check the corporate resolutions, you can check the Chamber of Commerce, etc., to check if the documents or the entity is still existing. Perhaps the entity was seized a year ago. This is just the most basic due diligence you can perform. So you have to check if the signatory is a natural person or a legal entity, and also verify the identity of the counterparty to prevent fraud. So be careful if you think you know the other party, because usually it goes wrong in the scenarios where you think you know the other party, or you might work with a friend because you can trust the other party, but because then things are not put down in writing, there is a lot of room for misunderstanding or disagreements in the end, because things are not regulated. So it's really important to put things down in writing, and I cannot repeat this as much as I can, I think, and check who is the counterparty. Is this counterparty authorized to sign? And even if you think you know the other party, is there any proof? Is there any documentation that shows this party is the counterparty and is capable to enter into such an agreement with you? I think we have some comments in the chat, so let me see if we can answer them. Meanwhile,
I'm reminding you, ladies and gentlemen, that you may always input your own views or points into the chat box. This is what our subject matter expert, Lynette Davidson, is checking right now on the chat box. Her session is very dynamic, interactive, with your participation, because remember, the conference, the class session is intended specifically for you. Thank you again, Lynette Davidson. You may proceed with your presentation.
thank you, Doctor. Yes, it's indeed mainly created for you. So if maybe one of you has a company or maybe is entering into a business-to-business agreement, or maybe you have learned from the experience, please feel free to share it with us so we can all learn and grow together. One of you, Herbert, meant you wrote to affirm commitment and protect the parties. Yes, that's true. It's really important to affirm commitments. So not only to create legal protection, but also for yourself, because if you want to foster a relationship, it's good to affirm your commitment and to stipulate the terms and conditions you are agreeing on together. It will help you both to have more clarity and more certainty, and you also have something put down into writing, so you always have something to back up on. I see another question here. My question is, what happens if the owners of the company are not known clearly? Perhaps you can clarify the question meanwhile, because I'm not sure what you mean with the last part, and then meanwhile we will proceed with the lecture. Because if the owners of the company are not the owners of the company, in that scenario, they're not capable and not authorized to enter into the agreement, because it must be someone who is authorized to enter into the agreement on behalf of the entity, the counterparty. So understanding the essential clauses in business-to-business contract is crucial for different things. We have just discussed that the business-to-business contracts, they govern the relationship between the parties, and you can think about different things. The first one, and that's maybe the most important one, because through the contract you might generate revenue, is to have clear payment terms. The payment terms should specify the amount of payment, the method of payment. For example, it can be in crypto, in euros, in dollars, native tokens. It can be many different things, but it needs to be specified. How will the money be transferred? Can it be cash? Must it be through wire transfer? What can you expect under the agreement? And also the schedule of payments. So the delivery term should outline the delivery schedule, responsibilities, etc. So it's really important to have this all well defined. And then we can also think about intellectual property rights, confidentiality, liability, and indemnification and termination conditions. I'm not sure if you can see my screen in full because it seems a bit faded here on the right side, but I will share my PDF file with you at the end of today's lecture. But if you think about confidentiality, many agreements, they stipulate that, for example, you are supposed to keep the confidential material confidential for the next 5 years. But then you have to think about, is this information actually confidential? Because it's not always needed for a term of 5 years. And then also, what is confidential information? It needs to be clearly defined in the agreement. If you think about intellectual property rights, we can think about, if I create an electronic product, for example, which has the third-party intellectual property rights included, I might not be able to give you the IP rights because I am not able to give you the ownership rights. So it's really important, if you create IP, what type of IP are you creating? Is there any IP of any third party involved? Am I even capable of selling the ownership rights to you, etc.? So take this in mind when you are concluding such an agreement. In terms of liability and indemnification, if you think about liability, is it reasonable to be liable for all cases? No, usually it's limited to direct damages only. And even if it's direct damages, could you maybe, for example, think about a cap? Or are you liable because it's deemed within your professional risk, for example? Termination conditions, if you think about termination, it depends on what type of agreement you're signing, because if it's a very long-term agreement, you might need a longer period to terminate the agreement. If it's a period of only, for example, 6 months that has been concluded, perhaps only 1 month might be sufficient. So it depends on the type of business-to-business agreement and what you can expect in such a situation, what can be reasonable as well to protect the parties. So now I'm thinking if maybe you could name some examples today of business-to-business agreements. Perhaps maybe you signed such an agreement lately. I'm eager to hear your thoughts on this.
Once again, brothers and sisters, this is a new invitation to a new call for your participation, and you are quite welcome to jump in and make your voices heard, or just input your comments on the chat box. There is a question that Professor Lynette that I saw a while ago, and I love that question. Apparently, it is now gone, but it cannot be gone. It has to be there. All right, I got it. It's a question from Nicholas saying, when a company in China, for example, signs a contract with another company, let's say in the UK, which country's law is applied? I love that question.
That's a very good question. Thank you for asking this question. You're asking if a company in the UK is concluding an agreement with a company in China, correct?
Yes.
Well, usually the governing law, you have the right to choose the governing law that's applicable to the agreement, but it should be linked to the agreement, which usually means that where one of the entities is incorporated, in this case, the UK or China, one of those laws would be applicable. And then it's up to the parties to decide which law is applicable. You cannot just, for example, choose German law if there is no link at all. It should make sense. So usually you pick one of the countries where one of the entities is established in. If, for example, you can also choose, for example, another jurisdiction as long as there's a strong link if it has the same type of law, for example, common law of UK. But the UK, for example, they have a very strong arbitration center. And it's one of the oldest and strongest ones as well. But it's up to the parties to decide the governing law, but it needs to make sense. You cannot just choose randomly any governing law. This is also something which we will discuss during today's lecture.
I love your response, Lynette, and I apologize if I want to piggyback a little bit further on this, and I truly believe this can prove important to every one of our attendees. Now, not too long ago, I live in Florida in the United States, and I was trying to purchase property in the Dominican Republic. I could use that property there for rental or as a vacation home. But as I was getting near the finalization of that purchase, I contacted my attorney here in the US, and that attorney says, well, there is nothing I can do for you because you're gonna go overseas, and the law in the United States cannot take precedence when it comes to goods and services in another country, which means there is, in that particular case, no particular law that could be applied. As a US attorney said, there is nothing we in the US can do for you if you're gonna do business with another country, specifically the Dominican Republic. Do you have a say on that, Lynette?
Yes, if you buy property, it's different. For example, if you conclude a business-to-business contract to perform services, and I am, for example, a manufacturer, and I have a warehouse here located in, let's say, for example, China, I can state that the governing law, Chinese law, would apply to the contract. However, the counterparty, a company located in the UK, if they apply their terms and conditions clearly, which states the governing law might be applying, their law might be applicable. When you buy property, usually the country where the property is located will govern. Property is something, if you buy property, it's something different than a typical business-to-business contract, because there are different and extra laws that could apply. And also the anti-money laundering laws are more stringent, and you should show the passport details, etc. You have to be present to sign the agreement. You can authorize somebody else, but it's more difficult. It's different than a typical business-to-business agreement. Real estate property is a specific type of field which requires additional clauses, let me put it that way.
All right.
Yeah.
Very, very clear. I hope that helps you, ladies and gentlemen, because again, the topic being addressed by Lynette at this time is business to business. It's nothing in terms of the example that I just came up with in terms of something that you are doing on a personal basis. The topic today is business to business. Thank you very much.
Thank you very much, Doctor. But I would like to clarify one thing, because it could happen that you buy property through a business-to-business agreement. For example, if my company would own a specific apartment building, I could still sell this to your company. So that could be a scenario where we could still buy real estate for a business-to-business agreement. That could still be an option. So I think that's good to keep in mind. So I think now, because of the time, we should
Yes.
proceed with the lecture.
Yes, yes.
So thank you for all sharing your thoughts, and thank you, Doctor, for the example. So if we think about payment terms and conditions in an agreement, I think you might want to protect yourself or the company from non-payment in the end. So there are different ways. These are just a few examples only we can think of. So the first one is, if we have project delivery payments, we can think about milestone payments. And why do we think of milestone payments? Because these type of payments are structured around key project milestones to ensure a cash flow and project accountability. What do you think could be the benefit of this? Well, it's quite straightforward. If I will create a specific product, which might take a year to create, and in order to deliver in full, I will have to make costs. Most likely it will cost me time, energy, and perhaps investments, finances, etc. So we could create together projects like project milestones in order to have the payments regarding phases. So for example, we could agree upon, let's say, 30 or 50% prior to signing the agreement, or upon signing the agreement, and then maybe the other 50% during the last phase of the agreement. But it depends on what type of product you are creating, what is the investment, and what could be the best percentage per milestone of payments. Usually you do agree upon 2 milestones as a minimum. This is to prevent non-payments unless you have 1 milestone upon execution of the agreement. But then if there's final delivery, you might want another milestone at least, right? So usually you do create 2 milestones as a minimum. Be careful though, if you do work with milestones, you have to make sure that the milestone is clear in writing. When is this milestone deemed to be submitted? Or when is it accepted by the counterparty? We can also think about advance payments, like I just mentioned. So you can think about a specific percentage of the total payments, which can be made up front. For example, if I am a kitchen manufacturer, or I am an architect and I create, for example, a specific, more complex design, I may need to make a lot of initial project costs in order to be able to proceed with the project. So I could ask an advance payment in order to be able to proceed and to deliver under the agreement. Then we also have consultancy invoicing, which is another example. We can think of payment that is based on the numbers of hours worked as agreed in the contract, where you specify the hourly fee, or perhaps you can think about the fixed fee. And then the applicable terms and conditions. If in the event there's going to be a late payment, then what do we do in such a scenario? Would there be a late payment penalty or interest? Could it be applicable? This can also be different per jurisdiction. And then also we have the currency and exchange rate. So if we, for example, agree upon payment in crypto, you might be aware that these type of valuations can be fluctuating a lot. So then what do we do? Do we agree upon a specific minimum in order to protect ourselves, or what can we agree upon if the type of currency might be more risky for terms of payments. So also you can think about the duration of the relationship. Is there any investments? Are there investors on board? How will we work together? Maybe we need periodic review of the agreements because we are starting up and we are just starting to sell specific type of products. Are we transparent towards each other? Do we trust each other? It's important to think about all of these things. And now what we just discussed, what do we do in case of a cross-border agreement and governing law? So if you think of cross-border agreements, this can involve different parties, right, from different countries. Then we should think of the legal jurisdiction, the governing law, the competent courts. There are different claim cultures. As you might be aware, the states have a very different claim culture than those we have in the Netherlands. And the parties should clearly define the applicable law and the jurisdiction in order to avoid ambiguity. Even if you choose a competent court, it might not be the competent court because they might not be able to handle the case, because they have to be the competent court to handle your type of disputes. So in case of any disputes, you should outline the process for resolution, and you can think about amicable resolution or mediation or perhaps arbitration, which might be sometimes a faster resolution. You can also pursue litigation, for example, for a more complex case, or perhaps the claim is of a very high amount. So you can think about a clause for mediation as the first step to resolve conflicts amicably. If you work with a mediator, this is usually a third party who is a neutral party, and you can share the costs for mediation. This is the most common type of clause. So the governing law should refer to the legal framework that will be used to interpret the contract, meaning the wording and the content. And it's crucial to select a governing law that's familiar and fair for both parties involved. And then also the liability. Well, what do we do in case of a breach or unforeseen circumstances? You can think about these type of clauses to minimize and manage potential risks. So I think it's really important for you today to think about, if you are entering into such an agreement, what could be the biggest risk for you? What are the risks you might want to minimize, or maybe what could be what can lead to uncertainty? And also, if you are not agreeing on the specific terms, then perhaps you can try to understand each other more, try to think about the market conditions, potential needs of each other. What does the other party need in order to operate the business? What are your objectives? Sometimes it helps a lot to have an open discussion and speak about the desired outcomes before entering negotiations. Because sometimes if you don't understand each other, it might go back and forth more than is needed. So it's important to listen to each other's needs and concerns and check if you're able to deliver according to each other's needs as well. And I think it's also important for you to create value for both parties, but you have to be willing to compromise sometimes as well. And I think you should also think about what could be the best alternative option in the event you don't agree. What could be the best alternative? What's the minimum for you to agree upon? I think there is a question here in the chat. Let me check it. Yeah, so the question here is, what factors should be considered when establishing the price cost negotiation to ensure it fits all parties involved? Well, that's actually depending on the type of agreement, the parties who are involved, what type of product is going to be delivered, and the type of services, for example. There is not a specific fixed price cost method because it may be different per type of agreement. So it's really important to think about, is there, for example, a big investment you have to make? Are you going to be fully dependent on this one counterparty when you're entering into this type of agreements? Are there still terms unclear under the agreements? Are you able to, for example, receive any advance payments? Or maybe receive 80% before a final delivery. So it depends on the type of agreement and the specific risks involved for both parties. So it's good to keep that in mind. And then now we can continue with avoiding the most common contractual mistakes. I am afraid because of the time, we might not be able to finalize today's lecture, but then we can continue with it next time, because I would like also to keep some time in case you have questions, so we can answer them today. But most of the most common mistakes are a bit straightforward, to be honest. But some people, unfortunately, they skim through a contract, or they read them like more briefly, or perhaps they don't understand the terms correctly, because a contract can have a lot of more complex terms. But it's really important to read the contract thoroughly, and you have to make sure that you understand all obligations and rights, because in the event there's going to be any loophole, it may work against you, and it can lead to a huge financial risk as well. For example, some parties, they would like to agree on automatic renewal. Other parties, they don't, because, for example, if you're a startup, you might not want to agree upon automatic renewal, because it might lead to unwanted commitments. Maybe you'd like to renew and review the agreements and the terms and conditions, because next year you might be in a very different phase than this year. Or perhaps you might want to renew the type of agreement automatically to save you time. So it depends on the type of agreement, what is most beneficial for the parties involved. Another common mistake is to overlook hidden clauses. One of them is to, for example, we can think about notice clauses, like if you're going to terminate the agreements, how are we going to give notice? Must it be 30-day notice or 15-day notice, or must it be in writing? So we need to be more clear about specific terms. So you can think about who is the company. If you refer to the company, who's the company? Is that only the subsidiary of the company, or can it be the group of the company? Services, what type of services can be defined here? What can we include in these type of services? What is the product? Is it going to be the end product, or is it product A, or maybe product A under the specific line? What is IP? So we should try to define specific terms if they are capitalized in the agreement, because then if they are capitalized in the agreement, it means a specific definition has been given to them in the agreement. So it's important to use consistently terms that are capitalized, because they have a definition as well as per the agreement. There is one more question here in the chat. So the question is, a B2B investment is not always having a victim either near or far between them. Let me see. So a B2B investment is not always having a victim. I'm not sure, Melanie, maybe you can ask the question, because it's true that it might not always have a victim on the foreground. Basically, it could be maybe somebody more far away. And how will delays be handled? Are there penalties or grace periods? So it depends also on the jurisdiction and what type of penalty is allowable, if it's permitted, and grace periods, and how will be delays handled. For example, if a payment is delayed, you are entitled, for example, to collect the fees through a debt collection company, or perhaps you can include the statutory interest rate. But this depends on the jurisdiction you are operating in and what is the applicable law as well. So I think, Doctor, we have to proceed next time with the last sheets of today's lecture, and we can maybe answer a few more questions today.
I fully agree with you, Lynette, as we are close to the allocated time, and I appreciate your sharing with us so much significant knowledge in the field of legal studies. But like you just permitted, let's try to take two questions with the two hands that I see now up, beginning with Ismael. We are ready for your question, Ismail.
Good morning, sir.
Hi.
Yeah, good morning, Professor.
Morning.
Yeah, good morning, everyone. My question is this. At first, before I ask my question, let me just say this. Thank you for the presentation. So God bless you, it's comprehensive. So the question is this: how can businesses leverage technology to streamline the process of creating and managing business-to-business contracts?
Thank you, Ismail.
Yeah, it comes.
Thank you for your question. So it depends on the type of company, if you can use technology to streamline processes. That's your question, correct? I
Yes.
think we are all lucky to have technology in our lives, first of all, because it can save us a lot of time and we are able to access much more information than, let's say, 30 years ago. So I think because of this, we are more able to educate ourselves and learn from a lot of different sources at the same time. So I think we can use technology definitely to grow and move perhaps forward faster, no matter the type of industry you may be in. But the type of technology might depend on the type of industry you're in. So, for example, there are nowadays AI tools or AI assistants that could maybe send emails on behalf of you, or maybe can help you to proofread contracts, or perhaps they can do the customer satisfaction processes for you. So I think it's important for you to check what is the most time consuming and creating the least revenue, or perhaps a lot of revenue, but maybe you would like to outsource the type of services. And if there could maybe be a technology tool that is able to help you to perform these services on a more automatic way. So it can save you time, and you can focus on what's most important for you, which maybe cannot be done without technology yet.
Okay, we're gonna try to accommodate
Okay.
one more question, and that is with Herbert Asokwo. Herbert?